Hello again. Welcome to this series of podcasts about the difficult, challenging, sometimes very sad, but critically important issues for family law of child abuse and child protection. In this first podcast, I'll introduce you to the module and discuss some of the research so that we can place our discussions about the law in an appropriate social context. First though, I want to deal with areas of Commonwealth and state responsibility. The Commonwealth has no power to make laws in relation to protection of children. By this, I mean that laws cannot be made for children to be placed in the care of a state welfare agency. Family law courts, that is, the Family Court of Australia and Federal Circuit Court of Australia, have no jurisdiction in relation to child protection. This means that those courts cannot make orders that a child be placed in state care, nor can they make any orders about arrangements, for example, the amount of time that a child might spend with a parent once a child is in state care. Each state in Australia has its own child protection legislation. In Queensland, the Child Protection Act 1999 applies. However, the issues of child protection of child abuse, that is, abuse of a child within the scope of the Family Law Act, are dealt with as one module in this course. This is not just for the sake of convenience. Many of the concepts across both jurisdictions are the same. You might ask, why does a family law court then even need to consider the issue of child abuse? Well, if a state welfare agency does not intervene and take action for the protection of a child or children, then a court exercising jurisdiction under the Family Law Act must make a decision, as between the parties to the dispute, whoever they may be, about a child's best interests. This may involve deciding whether or not abuse of a child occurred in the past, or whether or not there is an unacceptable risk of abuse occurring in the future. Let's move on though to look at some of the research about the prevalence of issues of abuse being raised in court cases, and also some of the broader research about the occurrence of abuse as reported in the community at large. A summary of the frequency of abuse being raised as an issue in court proceedings is contained at pages 326 to 328 of your prescribed text, Family Law Principles. Prior to 2015, parties were required to file a notice then described as a Form 4, setting out the particulars of abuse or risk of abuse. It's now a requirement for every party to file a notice of risk of abuse or family violence. In that notice, parties are required to detail either the particulars of risk of abuse or family violence, or in effect, make a positive statement that there is no risk of abuse. A study by Rosemary Hunter and some other authors, mentioned at page 327 of your text, found that in contested proceedings in the Family Court of Australia, cases with allegations or issues raised of child abuse comprised as much as 50% of those particular cases. Another example of some of the research is a report entitled A National Approach for Child Protection, prepared by the Australian Institute of Family Studies in 2008. This report is available through a direct link on your Module 6 learning page. There are some more recent reports available, but this report provides some useful background. It reports that as of 2007, there were 266,745 reports to statutory child protection services nationally. That was more than double the number of reports received in 2002, and at that time the rate was growing rapidly. Of those 266,000 odd reports, 55,000 or so, or perhaps nearly 56,000 of them, were substantiated. That is, that a child was in need of protection, and on the balance of probabilities, the notification was found to be true. Emotional abuse, which includes witnessing domestic violence, and neglect were the most commonly substantiated maltreatment types in Australia. The report says that as of 30 June 2006, there were 27,188 children and young people living in formal out-of-home care placements in Australia. That was almost double the number of children who were living in equivalent out-of-home care in 1996. Moving to some more recent research and reports, the Queensland Child Protection System was reviewed by the Queensland Child Protection Commission of Enquiry in 2013. Their report was entitled "Taking Responsibility, a Roadmap for Queensland Child Protection." That report was prepared by the Commission, chaired by the Honourable Mr Tim Carmody QC. The report is also available through a direct link on your learning page for this module. The report runs to more than 700 pages, so it is reading only for those of you who are more interested in deeper research and reading on this subject. The report, though, does provide some statistics. In 2011-2012, there were 24,823 notifications made, this is in Queensland alone, of a suspicion of a child in need of protection. And the department, that is the Department of Communities, Child Safety and Disability Services, as they're now known, conducted 23,852 investigations. Of those investigations, and remember there may be multiple investigations for one child or one family, 4,359 children were the subject of a finding that the allegation or notification raised was substantiated child in need of protection. What that means is that the child has experienced harm and or there is an unacceptable risk of harm. Of those children, 1,512 were subject to child protection orders. Another 2,383 children were the subject of consent-based intervention with parental agreement. Of the 1,512 children that were the subject of child protection orders, 1,059 of those children were placed in out-of-home care. Another 2,435 children were found to have the notification substantiated, but child not in need of protection. Just let me explain what that means. These were cases where the child had experienced harm and it was found on balance to be substantiated, but one parent was willing to act protectively. As a result, there was no ongoing harm or no unacceptable risk of ongoing harm that warranted departmental intervention. It is those types of cases where a child may be at unacceptable risk of harm, but one parent is willing to act protectively, that very likely fits the profile that might otherwise be dealt with by a court exercising jurisdiction under the Family Law Act. This very short overview has given us some context for our discussion on the state and Commonwealth laws. Thanks for listening. In the next podcast, I'll be looking at the Child Protection Act 1999, Queensland. Bye for now.